160 jury charge. Members of the jury, now that you have been sworn, I will give you some preliminary instructions as to the law to guide you in your participation in this trial. I will be giving you additional instructions at the end of the trial, and I may be giving you instructions during the trial itself. By the oath that you took, you are obligated to follow the law as I give it to you, whether you agree with it or not. And you must do your duty as jurors, regardless of any personal likes or dislikes, prejudices, or sympathy. That means that you must decide the case solely on the evidence that will be presented to you. In following my instructions, you must follow all of that and not single out some and ignore others. They are equally important. You must not read into these instructions or into anything I may say as a suggestion from me as to what the ultimate verdict should be. Deciding questions of fact is your exclusive responsibility, and in doing so, you must consider all the evidence that you will hear and see in this trial, and you must disregard anything you may see or hear elsewhere. Now, the attorneys are officers of the court, and it's their duty to present evidence on behalf of their clients and to make such objections as they deem proper and to argue fully their clients' causes. However, the arguments or remarks of the attorneys do not constitute evidence. If the attorneys make, or if I should make some statement as to what the evidence is and it differs from the evidence as you remember it, you should disregard the statements and rely upon your memory. And if an attorney's argument contains any statement at any point of the law which differs from the law which I give you, you should disregard their statements and rely on mine. During the trial, I may be called upon to rule on objections to certain testimony and exhibits. You should not concern yourselves with the reasons for my rulings, since they are controlled by rules of law. Objections as to questions are not evidence, and lawyers have an obligation to represent their clients, to make objections when they believe evidence is offered, which they believe should not be offered or admitted under our rules. If the objection is sustained, ignore the question. If it is overruled, consider the answer like any other. By receiving evidence to which an objection is made, I do not intend to indicate the importance to be given such evidence. You are to disregard all evidence that I order stricken. A fact may be proved by either direct or circumstantial evidence or by both. And you should know that the law does not prefer one form of evidence over the other. A fact is proved by direct evidence when, for example, it is proved by witnesses who testify to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proved by circumstantial evidence when its existence can be reasonably assumed from other facts proved in the case. You will be the sole judges of when a witness is to be believed and of the weight that you should give to the testimony of that witness. Now, there are no hard or fast rules to guide you in this respect. However, as to witnesses, you should take into consideration the following: their interest or lack of interest in the outcome of the case, their relationship to the parties, their ability and opportunity to know and remember and relate the facts, their manner and demeanor, their frankness and sincerity, or the lack of it, the reasonableness or unreasonableness of their testimony in light of all the other evidence in the case, any impeachment of the witness, and finally, any other factor that you believe bears on believability and weight. So in the last analysis, you will rely upon your good judgment and common sense. Some witnesses will be allowed to express an opinion. In determining the believability and weight to be given opinion evidence, you may consider, among other things, the education, training, experience, the knowledge and ability of the witness, the reasons given for the opinion, the sources of the witness's information, and those factors that I have already mentioned for evaluating the testimony of any witness. Opinion evidence is entitled to neither more nor less consideration by you than other evidence presented. You are to judge its believability and weight in the same manner as other testimony. Now, testimony may be presented to you by way of videotape or by videotaped deposition or by a simple deposition read. The testimony of a witness who, for some reason, cannot be present to testify in person may be presented in this form, and such testimony is under oath and is entitled to neither more nor less consideration by you because it is presented in that form. You are to judge its believability and weight in the same manner as you would had the witness been present in court. Now, a few words about your conduct as jurors. First, you should not discuss the case among yourselves or with anyone else during the trial. At the end of the trial, you will have as much time as you need to discuss the case among yourselves to arrive at a verdict, but that is at the end of the trial and not during the trial. Second, do not read or listen to anything touching this case in any way. If anyone should try to talk to you about it, bring it to the court's attention promptly. Third, do not try to do any research or make any investigation about the case on your own. Fourth, do not form any opinion until all the evidence is in. Keep an open mind until you receive all of the evidence. Listen to the final arguments and receive the final instructions from the court, and until you start your deliberations at the end of the case. Fifth, make a mental note of the seat that you are in and return to that seat after every recess and at the beginning of each day's activities. And finally, when you go home, friends, family will naturally be curious as to what you have been up to during the day. Tell them that the judge has instructed you that you are not to discuss the case with anyone, and that includes them. And when you get home, if something happens to be in the newspaper or on the radio or on TV, and it pertains in any way to this case, shut off the TV or radio or leave the area and tell members of your family to simply stack up the papers if there is anything in it until the trial is over. It is very important that your decision is based upon the evidence that is presented here in the courtroom and not upon any other item. If you follow these brief instructions as I have given them to you, you will be doing your duty as jurors.